Good morning. Every year in England and Wales, over 200,000 deaths are reported to coroners, and of those, over 30,000 end up in an inquest. That obviously affects a lot of people, and if you are one of them, perhaps a family member or related to the person who died, then you may be wondering what happens. I want to talk for a few minutes about what's involved and the practicalities of attending or even appearing as a witness in an inquest. Before we look at the practical aspects, I want to look at two big misconceptions which I hear a great deal. The first is that, possibly because the words are similar, is that an inquest will be an inquiry which will look at absolutely everything, no stone will be left unturned, all of the background circumstances will be investigated. I think this idea may have come from high-profile deaths and publicised inquests like the one into the death of Princess Diana, which involved evidence from nearly 250 witnesses and lasted 6 months. In real life, that doesn't happen. In my own view, if an ordinary member of the British public had died in a car crash in Paris, the inquest would have been over in perhaps a morning. But the way that was publicised gives people the idea that this will happen to the inquest they're involved in. It really won't. In fact, the remit of an inquest is very limited. It's just there to look at three things: who the deceased was, when and where they died, and how they died. And obviously the how allows a certain amount of flexibility to look at the story, but nothing like as much detail as people expect. With all of my clients facing an inquest, I will always tell them that they will certainly come out with issues left unexplored and questions left unanswered, and that's usually correct. The second misconception is that an inquest is an opportunity, if appropriate, to blame somebody. And if you think that your loved one has died because of somebody else's fault, then that's entirely understandable. In fact, that doesn't happen because it can't happen. The coroner's rules expressly forbid coroners from blaming individuals. What is slightly odd is that they can blame circumstances or systems, and so you sometimes end up with an odd situation where the death is blamed on, let's say, an operation that's gone wrong and there's only one surgeon been involved, or mistreatment in a prison cell and there's only one prison officer there. But the verdict itself cannot name individuals, and it can't be framed in a way so as to blame individuals. And again, some of my clients get disappointed when they learn that, because they look to people being held to account for the death. Okay, turning to the practicalities. Starting at the beginning, who can report a death to the coroner? Well, there's a belief that only certain people can: the police, perhaps a hospital, perhaps health and safety executive if there was an accident at work. In fact, anybody can. You can report the death of absolutely anybody you want to. When you do, the coroner's officers who you speak to may well ask, what's it got to do with you? But you won't be criticised for doing so. If you are somehow involved, then pick up the phone. The details of coroners, and there's usually one or two per county, are on various websites or in the phone book. Pick up the phone and either speak to a coroner's officer or write to the coroner and explain what's happened. As I say, anybody can report any death, but certain ones ought to be. Any fatality resulting from an operation, any death where the deceased hasn't been treated by a doctor in their last 14 days, an accident at work, if the death may have arisen from violence or negligence, or any death which has arisen from sudden or unexplained or possibly suspicious circumstances. That last one is, by definition, a very grey area, and that allows coroners or people reporting deaths to the coroner a certain amount of leeway. So once the coroner has learned of a particular death, they will need to investigate it, and the first step they undertake is usually to obtain documents, police records, hospital case notes, any accident records, exactly what you'd imagine. Having read those, it's very likely that they will then need to obtain statements from anybody who can help them. And by the way, don't believe that just because you have reported a death to a coroner, that automatically means that you will be asked for a statement. It depends what you know. If you do know something useful, then you can provide your own statement. What tends to happen in practice is that coroner's officers will come round and help you. They will help you draft the statement. They are usually retired police officers, and so they're very good at that. What, in my experience, they're not quite so good at is telling you afterwards that you are entitled to keep a copy of this. And most of my clients don't realise this. They will give their statement, not see it again, and then months or years later, when the inquest is looming, they can't remember what they've said. So if you're in that position, ask for a copy. They're obliged to give you one, and it will help you as time goes on. So, having read through any relevant documents and having obtained any relevant statements, the coroner then needs to decide whether an inquest is needed in the first place. Just because that process has started doesn't mean it will automatically end up in a coroner's court. As I said at the beginning, last year in Britain, 220,000 deaths reported to coroners, 30,000 inquests, so by definition only 15% of those ended up in a court. It's largely up to the coroner, depending on the facts. Certain deaths must go to an inquest. The main ones are any fatality that happens in a prison, or in a police cell, or in a railway line. Regardless of circumstances, the coroner has no choice there. That must go to an inquest. With the others, they may well find that the information that they've unearthed will explain perfectly well the cause of death. There's no need for a court hearing. If there is to be one, then how long will you have to wait? It depends entirely. It depends mostly on the complexity of the case and the number of witnesses likely to be called. Again, going to Princess Diana's inquest, that went for 10 years between the death and the hearing itself, which is extraordinary. But those were extraordinary circumstances. I read last week that in 2011, the average time between death and court hearing was 27 weeks, which I must say I was slightly surprised by. I specialise in medical deaths and medical inquests, and very few of those would last less than a year between the fatality and the actual court hearing. But it may well be that elsewhere there are much more straightforward, simple inquests which are heard more quickly and bring the average down. One thing I do need to explain at this point is something that quite often confuses my own clients, and I'm sure confuses a lot of people, which is that at the beginning of this process, the family members, and perhaps others, will receive a letter from the coroner saying that he or she has opened the inquest, and they will, understandably, believe that the actual court hearing has begun without them and become troubled by that. In fact, the reason is this: by law, the body cannot be disposed of, buried, cremated, whatever, until the inquest has been opened. Now, it would be terribly unfair if families were made to wait 6 months, a year, a couple of years, until the inquest has actually started before they can bury or cremate their loved one. So what actually happens is that the coroner will sit in his or her office, declare formally that the inquest has been opened, and then immediately adjourn it for the investigations. That way the body can be released for disposal, because sometimes the inquest may be a very long time before it's held. During these investigations, there is sometimes something called a pre-inquest review, which is exactly what it says. It's an opportunity for the coroner and the family members, any legal representatives on either side, other witnesses, to sit around the table and talk about practical aspects, if any more documents are needed, if any particular statements may be required. Of the witnesses who are producing statements, which of those need to be giving evidence in person, and which of those can simply have their statements read out? That's something else that not many people realise. When family members are given a list of which witnesses will be giving evidence at the inquest, some of those witnesses will have Rule 37 or just R37 against their names, and the family would reasonably assume that all of those people will be turning up in person and giving evidence in court. In fact, Rule 37 means that that person's statement is read out, but the person themselves doesn't need to be there, and by definition won't be able to answer questions. So the pre-inquest review, as I say, it's only held in complex cases, but if it's held in your case, that's a good opportunity for you to say, I don't want this particular individual to be admitted under Rule 37. I want them there in person. I want them to answer questions. Come the inquest itself, what can you expect? Well, apart from any inquest involving national security, which is extremely unusual, all coroner's hearings are open to the public, which means that you don't need to be a witness to go along and watch. If you are a witness, then beforehand you will have received a letter from the coroner asking you to turn up. What isn't often realised is that that letter, no matter how informal or polite it may seem, that letter actually constitutes a witness summons, which means you have to turn up. If you don't, it's contempt of court, which is a crime. So if you are a formal witness in a forthcoming inquest, please don't believe that because of stress or worry or unavoidable circumstances you don't need to turn up. You will. You'll be committing an offence if you don't. On the day itself, the witnesses will give evidence, usually in the order that things occurred, so that the story unfolds as it actually happened in real life. The exception to that is that if there has been a post-mortem, then traditionally the pathologist will usually give evidence first. That is so that people know the medical cause of death before they then start looking at the background story. All witnesses, including the pathologist, if there is one, will answer questions from a witness box. In criminal or civil trials, virtually all of the questions are asked by the barristers or solicitors, with the judge occasionally intervening or asking sporadic questions. It's quite the opposite in the coroner's court. Virtually all of the questions are asked by the coroner, and then after that, if there are legal representatives, then they will ask any questions as well and cross-examine the witnesses. There's nothing to stop family members from instructing a lawyer to represent them, but bear in mind that there's no legal aid for inquests, and so unless you have some sort of insurance cover which may fund you, then you'll have to pay for lawyers privately. If you don't have a lawyer, then the family can ask questions of witnesses themselves, but only via one spokesman. The coroners are very much against all the family members popping up and each of them asking questions the whole time, so you'll need to choose one person who speaks on behalf of the family. Once all of the evidence has been heard, the coroner will usually adjourn for consideration of a possible verdict. In a very long and complex inquest, that may take a few days, in which case you'll need to reassemble sometime later to hear the verdict. In most fairly straightforward hearings, the coroner simply goes off for 20-30 minutes, an hour, whatever, and then the court adjourns during that period and reassembles, and the coroner will then sit and give a formal verdict. That will usually involve a summing up of background, but the verdict itself is much briefer. So after possibly an adjournment, the coroner then hands down a verdict. Until 10-15 years ago, coroners tended to give the traditional short form verdicts. I'm sure you've all heard of misadventure, suicide, accidental death, open verdict, etc. The difficulty with those is that they gave the family very little explanation. If you have waited a year, 2 years for your day in court, and then you spent a whole day, possibly longer, sitting through the inquest, at the end of that you want to know far more about how your loved one came to die than simply accidental death, misadventure. So because of that, coroners now are encouraged, they can't be forced to, but they're encouraged to return what are called narrative verdicts, which is a couple of paragraphs giving much more information. And bear in mind that before the verdict itself, the coroner will also sum up, and in that summing up there's quite often a good deal of information which reveals how the coroner is thinking. So a narrative verdict is much more helpful for the family. They can still add a short form to that, and one which the family sometimes look for, and any organisation perhaps implicating the death tend to avoid or try to avoid, is neglect, because neglect essentially means that this person has died because somebody has made a mistake, or a system is at fault, or some sort of organisation was culpable. But as I said earlier, they can't point the finger of blame at individuals. once the verdict has been given, the inquest comes to an end. Because virtually all coroner's hearings are open to the public, that means that they are also open to the press, and I've been an advocate at perhaps 200, 250 inquests over 20 years, and I would say that the press have been there in perhaps 3/4 of those, which means that there's likely to be something in the local or regional papers the next day. If you feel strongly about what's happened, having sat through the inquest, then seek out the journalists, give them your side of the story. They look for quotes from family members, and so I think you'll find a receptive audience there, but there will almost always be journalists at most inquests. Okay, that's all I wanted to say today. I could talk for much longer about, for example, the relationship between a critical inquest and a subsequent civil claim for negligence, or the complex relationship between inquests and Article 2 of the Human Rights Act, which is the right to life, which gets a lot of lawyers very aerated, but we don't have time for those today. It was a quick gallop through a lot of issues, and I've only touched on some of them, but nonetheless I hope that was helpful. Thank you.